Well, I want to thank the National Shattering Silence Coalition for inviting me to speak today. I really appreciate the opportunity. I got started in this field back in 1990 when I first became a probate judge, and it didn't take me long to notice that the people I was seeing had been seen many, many times before. It wasn't unusual to have someone come in front of me who'd been in court 30 or 40 or 50 times on a commitment. So something wasn't working. Uh, and that led me to down this path. But I can say today that, at least in Michigan, we have the tools to stop the revolving door, and we can do it with early intervention and collaboration and use of assisted outpatient treatment. So let me start with the revolving door. What is it and how did this happen? Well, the revolving door is basically the endless cycling of people with mental illness that relies on short hospital stays without connection to treatment in the community. It's ineffective, it's frustrating to healthcare workers, and it's harmful for those with serious mental illness. And after all, mental illness is a chronic condition that's not controlled by a series of short emergency department visits or short hospital stays without connection to treatment in the community. So how did this happen? I've discussed the impact of the Community Mental Health Act of 1963, the financial incentives to close institutions, and the promise of a system of outpatient treatment. So the Community Mental Health Act of 1963 made a couple of promises. The first was the federal government would pay for the cost of treatment for indigent persons with mental illness, provided they were not in institutions or hospitals. Though this incentivized states to maximize the use of federal dollars by shifting as many general fund dollars as they could in order to support those who become disabled or poor, but didn't leave much for the persons who were not Medicaid eligible. So state mental health programs that once were public mental health programs became Medicaid mental health programs and became needs-based. So one could ask, did this undermine the popular and political support for public mental health services? After all, persons with serious mental illnesses don't have expensive lobbyists. So the problem was the second promise the federal government made was we're going to have a system of outpatient care to take care of people who will no longer be in the hospital. Well, that didn't happen. That was a huge problem because at the same time, we had new state laws that did not permit early intervention in the course of someone's mental illness and did not provide for transition to outpatient care. The only option was inpatient care. And the system was designed to intervene only in crisis and then only to stabilize and did not provide a process to promote recovery. So this has been the process in our country for nearly 50 years and is deeply embedded in the culture of treatment. And as I'll mention later on, having a shiny new law isn't enough. So overcoming the resistance to care has been a historical fact for 50 years. So now that we have the Community Mental Health Act in place, we find that about a third of our homeless people have a serious mental illness. We find that nearly 2 million people with serious mental illness will spend time in our nation's jails and prisons this year. As of last November, 34% of Michigan's prison population was receiving mental health treatment. And people with mental illness are 16 times more likely to be killed than any other civilians when approached by law enforcement. And of course, for those prisoners who have a mental illness, it's even worse. First of all, they are found to serve longer sentences. They're more likely to commit suicide. They have more parole and probation violations. They have higher rates of recidivism, and they're more likely to be placed into administrative segregation. And of course, there are the harms that result from delaying treatment, starting with permanent incapacity. Failing to treat mental illness for years can result in the person requiring the appointment of a guardian. Incarceration is an obvious risk of delay in treatment, along with poverty, homelessness, isolation, and poor health, including a shorter life expectancy. And of course, a loss of resiliency, the ability to bounce back from an episode. And in addition to these risks, the risk of untreated mental illness increases the risk of dementia, drug abuse, and suicide. All of these are potential harms from delaying treatment. So why do we do it? Why do we do it when, with early intervention, much of this risk can be reduced? Well, the 1990s saw the emergence of the recovery model. And in the recovery model, mental illness is seen as treatable, recovery is possible, people can lead satisfying, productive lives. That is, if we treat early and don't wait for crisis. Michigan's Mental Health Commission in 2004 found that we need to embrace the recovery model, but the mental health codes are not designed to support the recovery model. They are inpatient models in an outpatient world. So Michigan did adopt Kevin's Law, or AOT, in 2004. And I thought I would relate what exactly the sponsor wrote in his press release. He said, until today, families had to wait until their loved ones made a threat or actually hurt someone before they could get help. And then the only option was inpatient care. Now people can be helped earlier and on an outpatient basis. If the treatment is successful, the person never needs to reach a crisis point and hospitalization may be altogether averted. I agree completely with that statement. The only thing is, the legislator did not read the statute because that did not change. The statute he wrote provided you had to have 2 crises, and then you had to start out in the hospital. So his promise was unfulfilled until 2018. And in 2018, we were able to secure amendments to Michigan's law so that this statement is now true in Michigan. So in terms of our new laws, first of all, our standard for intervention, the standard for ordering treatment, involuntary treatment, you won't find the words danger to self in there or others. That is no longer a part of our lexicon. Instead, we look to the risk of harm that is posed by untreated mental illness. And it's the immediacy of the risk of harm that governs whether hospitalization or outpatient treatment is required. I'll talk a little bit about that standard and how the Court of Appeals has interpreted it. So just to summarize, Michigan's new model, we modified our mental health code in 2018. We don't have to wait for crisis to intervene now. We have no petitions for hospitalization. We only have petitions for treatment. We have a system where the court can order outpatient treatment without hospitalization. No need to go to the hospital at all. And the requirement that there be a threat of harm or that the danger be imminent is no longer part of our code. The new focus is on the risk of harm that's posed by refusing treatment. And then it's the immediacy of the risk of harm that governs whether to hospitalize or order outpatient treatment. So this is kind of a standard statute. It speaks to a person with a serious mental illness who can be expected to seriously injure someone in the near future, and they've engaged in an act or made threats that supports that. Notice it doesn't say when that act or threat had to be made. Recent Court of Appeals decision said an act from 2 years ago would support the expectation that the individual now in his current state could be expected to hurt someone. But the real change is in what's called 401C of the Mental Health Code. And what we have here is if we have an individual with a mental illness that doesn't understand the need for treatment, they're refusing treatment, and they're at risk of relapse or harmful deterioration, and that creates a substantial risk of significant physical or mental harm, then the court can order treatment. We've got a very interesting Court of Appeals case on that one. In this case, the Court of Appeals held that testimony from a doctor that untreated schizophrenia increased the risk of dementia, drug abuse, suicide, and further decompensation, including delusions and paranoia, was sufficient to order involuntary treatment. But what was most interesting about this decision is that in this case, the doctor testified that the respondent was not at risk of harm at the time of the hearing, but he was at risk of harm within 3 to 6 months due to his lack of insight and history of decompensation. So despite the fact that he was not at risk of harm at the time of the trial, because he lacked insight, because he had history of decompensation, the doctor concluded that, yes, indeed, within 6 months, he will be at risk of harm, and these are the kinds of harms he'll be at risk of. And therefore, the Court of Appeals affirmed the lower court order ordering treatment. So this is our new decision tree. The question is, we start out with, does the individual have a mental illness? And is the person's judgment impaired? And does that impairment cause a lack of understanding of the need for treatment? If so, we go to the next question. Is the person unwilling to engage in voluntary treatment? And that's not just a matter of saying, will you engage in treatment? Yes, no. No. You have to look at the history. Just like the Spalding case I just cited, they looked at the history, and they knew that a statement that the individual agreed to treatment was demonstrated to be unreliable due to his history. So if you conclude that the person is unwilling to engage in voluntary treatment, you go to the next question. Is that treatment necessary to prevent a relapse or harmful deterioration of the person's condition? And would that present a substantial risk of significant physical or mental harm to the person or others? Assuming all of that, the next question is, so what is the immediacy of the risk? The more immediate the risk, the more likely hospitalization will be ordered. So now we have a system that allows for early intervention without the need for a crisis, without the need for an arrest. So that enables us to use assisted outpatient treatment. And in Michigan, assisted outpatient treatment can be used on any petition for treatment brought before the court. AOT is an evidence-based tool. It promotes recovery, reduces harmful behavior, lowers hospitalization and emergency room use, as well as reducing costs. We have great data from New York now, and pretty good data from Ohio, and as well as data from Washington, Florida, Arizona, North Carolina, Nevada, and Michigan that demonstrates the value in promoting recovery and reducing ER visits, hospitalization, arrest, and incarceration with high levels of satisfaction. I can tell you that years on the bench, it was very rare for anyone to be satisfied when I ordered them hospitalized. So we now have two pathways to care in Michigan. The first is the traditional method of filing petitions for mental health treatment from the hospital. That is the traditional method. We have a new method in Michigan, and that's called AOT only, where we bypass the hospital and file a petition directly with the probate court. And I'll get into that in a minute. The current system basically provides that the petition for mental health treatment provides an option to request either hospitalization or hospitalization and AOT or AOT without hospitalization. The hospital is required to schedule a deferment conference and invite the community mental health treatment team or representative to the hospital to discuss the plan for outpatient treatment. And if the individual agrees to that treatment, then the petition is deferred for up to 180 days, and then the hospital is required to release the individual to the outpatient treatment provider. That's a pretty good thing, because if the person is released to the provider and is not compliant, then you come back to court. And then in those cases where they've already been to court and the court has entered an order for hospitalization and AOT, the hospital is required to give 5 days notice before discharge may occur. Now, this is where that culture problem comes in. Historically, AOT wasn't available. So the hospitals have not been scheduling deferment conferences. At least they're not inviting the CMAs to the table. And without CMAs to the table, it's a deferment to nowhere, because the person signs the deferment, they're released from the hospital, the community treatment team is unaware of that, and there's no follow-up. I've had numerous complaints from providers of not getting the 5 days notice. In fact, we had a recent case where the Wayne County probate judge found that the individual was discharged without notification to the community treatment provider. He scheduled an order to show cause for contempt against the hospital. This did lead to improved performance, but we are really struggling to get the hospitals on board to understand why that deferment conference is so important. 1/3 of all the petitions filed in Michigan every year go away by a deferment conference. And if they just go away, that's a problem. That creates that revolving door problem. So I say all this because that culture is really important, because the culture is slow to change, and that's whether it's inertia or outright resistance. But if you don't get compliance with this, you're going to have trouble with the system. So we're still working on that. But here's our new system. And that is, you file the same petition, but you only ask for assisted outpatient treatment. No clinical certificates are required. You go to court with a bare petition, and you indicate that your loved one has a mental illness, they meet the treatment requirements under the statute, and the court will schedule a hearing in 28 days. And during that time, you have to find expert testimony in the form of a psychiatrist in order to testify. And that's actually a problem because we don't have that many psychiatrists. We have a bill pending which would expand who can testify to include psychiatric nurse practitioners and physician assistants who are under the supervision of a psychiatrist. This should be able to allow us to have many more people available to testify in these cases and get more people using the system. Frankly, AOT only means we go to court before this crisis. And I would hope this will be the preferred method of operation in the future. In the event a person refuses to be examined, the court can order examination and the police can be ordered to transport the individual to a crisis center for an evaluation and then be released. This system also allows for mediation. Since the hearing is not scheduled for 28 days, Michigan has these community dispute resolution centers that cover the state, financed by the State Court Administrative Office. We have trained mediators who received additional training under the Mental Health Code. And we now have cases where instead of going to a hearing, the individuals go to mediation. And the majority of the cases that have gone to mediation have settled at mediation. And what that means is you've got engagement. Because I can tell you from my experience that a mediated agreement is far more likely to be acceptable to the parties because it's their choice than it is when I issue an order. So we now have a mental health code, at least in Michigan, that's an outpatient model in an outpatient world. So intervention can take place before crisis, and the court can order assisted outpatient treatment. There's no special provision to order AOT. You don't have to fail twice or once. You don't have to have a history of hospitalization or incarceration. It's not required. It's a ridiculous requirement. There are no review hearings. This is not mental health court. If there's non-compliance, we can have a hearing or a status conference in order to address the issue. I can tell you that in Genesee County, located where Flint is located, they have 90% compliance by people on AOT. And the people on AOT last year had a lower hospitalization rate than the people who were not on AOT. Now, we have identified so-called familiar faces. These are individuals with significant amounts of appearances in the court. And so what we're going to do in Wayne County is have a monthly conference with the respondent and the treatment team, which can be helpful because our new system creates accountability, not just for the individual, but for the system. So if a person is found to require treatment, we can order treatment for up to 180 days to a community mental health services provider or another entity designated by the MDHHS. And I can see us using the certified community behavioral health centers for that. The court can order case management services, medication, blood and urinalysis testing, individual group therapy, educational vocational training, supervised living, assertive community treatment, alcohol and substance use disorder treatment and testing, and any other services that are prescribed. So these are the kinds of things that basically the court is authorizing. And once the court enters the order authorizing that, then it goes to the community mental health center. And they are to provide a psychiatrist to supervise the preparation and implementation of the actual treatment plan. And that plan has to be completed within 30 days and forwarded to the court. If the AOT plan is not forwarded to the court, that triggers an inquiry by the court, where's the plan? And this helps to assure that we have the warm handoffs that are necessary to make this all work. So what we do know is AOT is effective at stopping that revolving door. New York data shows that hospitalization was reduced by over 70%. Length of hospital stay was reduced over 40%. Arrest down over 80%. Incarceration down over 80%. homeless nights down over 40%, and 92% satisfaction with AOT services by individuals. I can report that so far this year, Genesee County in Michigan has served 713 distinct individuals. They typically have about 400 people on AOT or deferrals at any one time. And since the grant was given by SAMHSA to set this up, they've served about 1,370 distinct individuals. And the result of all that, hospital recidivism for these individuals has dropped by 51%. So I wanted to point out this AOT participant satisfaction survey, because I can almost guarantee you that the people who came to my court to be committed to a hospital didn't feel particularly satisfied. But this study coming out of Ohio, there's a link at the bottom, found that AOT participants reported high levels of satisfaction and feelings of empowerment, which is really important, with regard to both their treatment team and the courts. More than 3/4 agreed they're satisfied with the treatment team and with the courts. And most felt they received benefits from the court order and from participating in the program. I can tell you that in a couple of our counties, people on AOT will come into the court or come into the CMH and say, look, my AOT is expiring. We got to get it renewed. And even if the CMH says, well, not really sure you still need to be on, no, I want to be on the AOT, and they rely upon it. An interesting data point was that Black participants were significantly more satisfied with their treatment team and the courts than white participants. This may have something to do with the fact that access to care has been a real problem for minority communities. The aspect of the program that the AOT participants liked the best was the people. And for some, this was the treatment team, and for others, it was the judge or the magistrate. And that brings me to the AOT toolkit. I chair the Mental Health Diversion Council, and we have contracted with the Center for Behavioral Health and Justice at Wayne State University to develop a toolkit that can be used by probate courts, community mental health systems, hospitals, law enforcement, and others in order to promote the use of AOT across the state of Michigan. There's a link there. You can Google AOT Toolkit Michigan. You'll find it, explore it. Provides an overview of legislation, roles, and the court process of AOT. And it's a resource for those who want to learn and are currently working in the realm of AOT or have a loved one who needs help. So it's for everybody. It's updated regularly to reflect feedback from users and policy changes. We will continue to add content and add clarity, accessibility, and more in-depth information for all parts of the system of care. There are specific sections with trainings from experts that are aimed at clinicians for enhancing their capability. Bottom line is, AOT obligates the mental health system to actively engage with those whose mental illness prevents them from seeking treatment voluntarily. And that's a key aspect of AOT. I like to cite this quotation from Eric Smith, an AOT graduate, and I met him at a presentation in Texas. He had a long, sad history, and so he was ordered into AOT. And he's had a remarkable life since then. But this is what he said. Advocating for a person in a decompensated state of mind to be able to refuse treatment is not a protection of liberties. Rather, it serves to deny a diagnosed person's ability to pursue liberty and choice, as liberty and choice are suffocated by the presence of untreated, undertreated SMI. Freedom, choice, and liberty cannot and do not exist until someone becomes stabilized and sane. I recently saw a study by the University of Michigan. It's a 5-year study of 6,405 individuals with bipolar disorder. And they asked them what wellness meant to them. 17% said a reduction of symptoms, but 76% said healthcare systems focused on symptom reduction. So in other words, it wasn't meeting their needs. So what they said was wellness to them meant by 86%, the ability to be independent, to act according to their own will. They want to be in control of their emotions and decisions. And that's the objective. I mean, the purpose of early intervention is to promote the ability of persons with bipolar disorder and other mental illnesses to be able to be independent and act according to their own will. Delaying treatment damages this ability and can ultimately lead to the appointment of a guardian and loss of all ability to be independent and act according to their will. So we need to be listening to people with lived experiences like Eric Smith. So having a nice, shiny new law is a great start. The culture needs to be addressed, but more importantly, collaboration. It takes a team to make this work now. And when I say it takes a team, it takes a community to make the mental health system work. And that means the courts, law enforcement, families, community treatment providers, emergency departments, hospitals, and mental health advocates. But state leadership is critical to get started. My recommendation is that governors should establish mental health diversion councils in order to begin to tackle the problems in their state. States should establish a dedicated office to support crisis intervention training, as well as assisted outpatient treatment. That kind of direct leadership is really critical. And then, consistent with the recommendations of the National Judicial Task Force, a behavioral health unit should be established in the administrative branch of each Supreme Court. Several states are doing that now. Illinois, I think, is one of the most recent ones. Now, in Michigan, the formation of the Mental Health Diversion Council led the way to reform of our system. And we had leadership from the Lieutenant Governor, the Speaker of the House, and the chairs of House Judiciary and Health Policy. That was critical. You need a champion in the legislature to help lead the way. The Diversion Council itself is a diverse group of stakeholders that has developed legislative language and has been funded to study diversion from the criminal justice system and implementing AOT. The Diversion Council funded the work of Wayne State University Center for Behavioral Health and Justice to create the AOT toolkit, and that's been invaluable. We also rely upon the center to analyze data. They're fantastic at that. So the Diversion Council also drafted a bill to divert persons charged with misdemeanors from the Forensic Center to AOT programs. In other words, if you're charged with a misdemeanor, you've got a mental health problem, we're going to AOT, drop the criminal charge. Don't use the Forensic Center. It's overcrowded now. Currently, the Diversion Council is funding behavioral health training courses to equip emergency first responders across the state with the tools they need to recognize, respond, and mitigate a behavioral health crisis incident. So this leadership by the state is really critical. It is the raw material, the infrastructure that's required to enable community partners to end the cycle. And we're fortunate in Michigan that we have achieved that. We have the infrastructure. But then it gets down to the community. And it starts with the courts. The courts, the one thing judges can do is convene stakeholders. You may be familiar with Judge Steve Leifman. He became the public defender down in Miami-Dade many years ago, and he went to the jail and saw the horrid conditions for the persons with mental illness. So he invited the stakeholders to a meeting to discuss this. Nobody showed up. And a few years later, he became Judge Steve Leifman. He invited the same stakeholders. They all showed up early. So judges have convening power. We may not have all the answers, but we know who does. So you've got to convene the stakeholders in the system. And then you have to have regular meetings. Like Genesee County did them on a monthly basis in the beginning, but now they're quarterly because they're working through everything. I recommend that the courts either conduct sequential intercept mapping or work with the community mental health system to conduct the sequential intercept mapping. I recommend that all mental health hearings be held remotely. We've been doing that for years in Michigan. Some of these other things are unique to Michigan, but the one thing that is vital is tracking these AOT orders and staying on top of it. So Wayne County, Michigan, where Detroit is located, created a behavioral health unit within the Wayne County Probate Court, and they literally track every file. So once a petition is filed, they're making sure there was a deferment conference that was complied with. They're making sure there's discharges as provided by law. They're making sure that AOT treatment plan is put in place and they're monitoring to see how it goes. All of those things are vital if you're going to assure warm handoffs all along the way. Next is law enforcement. To me, this is a rather stunning statistic that police are involved in the pathway of care for almost 1/3 of all people with mental illness in the United States. I'm pretty confident that's not the case for any other illness. But law enforcement needs to have crisis intervention training. It's proven to be successful in drastically reducing injuries to law enforcement as well as injuries to persons with mental illness. I urge law enforcement to transport persons to crisis centers if they're available rather than a hospital, because you're more likely to get the right person at a crisis center. And then I advise law enforcement, they need to be familiar with the new standard for intervention in Michigan. And when they go to someone's house and they decide that this isn't a case that requires hospitalization, they can at least tell the family, you could file a petition for AOT only and advise families of that option. And I urge law enforcement to consider co-responder models. These are just some of the things that law enforcement can do or should do. It's not exhaustive at all. Community treatment providers, I advise them, consider mediation at the first sign of non-adherence to treatment. The community treatment providers know their consumers, and they also know when they're starting to have a problem with compliance with treatment. When I was hearing these cases in court, I'd ask family members, so when did he stop taking his medicine? And they say 6 months ago. So we all knew where this was heading. We just had to wait for the crisis. We don't have to do that anymore. So if a person begins to show signs of non-adherence, you can go to mediation immediately and find out what the problem is and correct it and maybe change the medicine, change something. And then I still suggest that if you're at non-compliance, you have to get a court order for assisted outpatient treatment, go ahead and file the petition, but seek mediation before the order is actually entered. Failing that, they have to provide testimony at the hearing from a psychiatrist, and most community treatment providers do have access to that. But it's also important for the community treatment providers to have a relationship with referring hospitals, because you've got to have that connection. Then the emergency departments. The EDs are the primary gatekeeper. And the big challenge with them is applying the proper standard for persons who enter the emergency department. If they meet the standard for treatment, but the risk of harm does not require hospitalization, I urge that they connect with community treatment and have the person treated there, or file a petition for AOT only. In my training of case managers, they're actually enthusiastic about the idea they could actually file a petition for AOT only without admitting the person to the hospital. It's a great option. And then another aspect is consider AOT as an alternative to guardianship. AOT is limited in time, 180 days. Guardianship tends to be permanent. AOT is limited in terms of what you can do. It's consenting to mental health treatment, as opposed to guardianship, which has all kinds of controls. And if we use AOT as an alternative to guardianship, we may never have to have a guardian appointed. And then I suggest that there be a memorandum of understanding between the emergency departments, the community mental health system, and any CCBHC in order to assure that people who are in need of treatment are connected to an outpatient treatment provider. And then finally, hospitals. It's critical that they apply the new standard to determine if a person requires treatment in the hospital or in the community. That's still a problem today. I still have doctors saying, you mean danger to self or others is not the standard? Yes, it has not been the standard for 5 years now. So, and then when they're discharging a patient from the hospital before the hearing, that doesn't necessarily cause the part of the petition that seeks AOT to be dismissed as well. In one of our counties, the petition was filed for hospitalization and AOT, and the hospital called the court and said, well, patient's been discharged, we will not be presenting a doctor. And the judge said, oh, yes, you will, because the AOT petition is still pending. And the hospital said, well, we're just not going to do that. The judge said, well, I have this order to show cause we could use, or you could just show up voluntarily and provide testimony. The result has been that the hospitals now provide testimony, and he's not seeing people as often as he used to. So Probably the most important thing that hospitals can do is to notify CMH of the deferment conference, and if the matter is deferred, release the person to the CMH. And these are two requirements in statute. So they aren't optional, they're not best practices, they are requirements by law. And it is a tremendous problem with the healthcare system and its non-compliance with this particular feature. But we are working to get that compliance. It's just going to take time. We're changing the culture, and that's hard to do. And then if a person's is hospitalized on a combined order, the patient cannot be discharged without prior consultation with the outpatient treatment provider. Statute says you've got to get 5 days notice. Well, in a very short hospital stay, that might not be possible. But it is not impossible, if the patient is in the hospital on combined order, to contact the outpatient treatment provider. I think the courts will be lenient on how many days notice you give, but they won't be lenient if you don't give notice at all. So it takes a community to make the system work. Everybody plays a role. Connection and communication are vital to assuring warm handoffs to connect people to treatment. At least in Michigan, we have a system of outpatient. We have an outpatient mental health system, which can allow for early intervention, the use of assisted outpatient treatment, and substantially reducing the amount of hospitalization required. I want to thank you for the opportunity to present, and I'll be happy to answer any questions.
Judge Mack?
Yes.
Yes, this is Dr. Creekmore, Edmund Creekmore. I'm intrigued by the 80% reduction in arrests. Has Michigan enjoyed more success than other states in being able to divert misdemeanors who tend to be sicker? They tend to have more serious mental illness, and getting these individuals dropped off by the officer who's on the scene has to make a decision. Am I going to arrest if they commit a misdemeanor offense, like destruction of a mailbox or petty larceny or an offense like that? Has Michigan been more successful than Virginia and other states in diverting getting the officer to drop off these patients at your crisis stabilization units or crisis receiving centers, and avoiding their having to enter the criminal system where they may end up having to go someplace for a competency assessment once they get into that system? So what has been the Michigan experience in diverting these types of misdemeanor offenders who tend to be more ill?
Well, we have over 200 problem-solving courts, which sounds pretty good. And they are successful in terms of the people they see. However, the Center for Behavioral Health and Justice, in their survey of Michigan's jails, found that only 3% of the prisoners who were there on misdemeanors who had a serious mental illness were actually in a problem-solving court. So I would say the success rate's not very good. However, we have this bill pending, and it's supported by the Michigan Prosecutors Association, Disability Rights, NAMI, CMH, and a number of others. And we think once this bill is adopted, and hopefully it will be adopted, it'll almost be an automatic referral of misdemeanors from who are suffering from mental illness to assisted outpatient treatment. And the way the system would work is instead of going to the forensic center, you go to CMH for an assessment about whether you need AOT. And if they say, yes, you need AOT, and no one objects, the order is entered, and the criminal case is dismissed. But that's really going to that'll be a game changer.
Thank you very much.
Judge Mack, we have a few questions in the queue.
Okay.
Leslie Carpenter says, I love that the hospital is not allowed to discharge a patient without communicating with the outpatient treatment team. Is that written into code, is your question? And
yes.
What happens if they don't?
Well, like I said, the case that Judge Burton had in Wayne County, he did an order to show cause for contempt against the hospital. And the attorney showed up begging for forgiveness. Judge Burton said, what are you going to do about it? I said, we'll have a new policy so this doesn't happen again. Judge Burton said, well, I'll adjourn the hearing. You come back with a new policy. And by the way, what happened to this gentleman? And the lawyer said, we don't know. And Judge Burton said, well, see, that's the problem. So it's pretty harsh to use the contempt process, which we prefer not to use, but it can be used. And I would also say we had a hospital that did this before this increased enforcement occurred, and the individual was killed. There are plenty of plaintiffs' lawyers out there who love a case like that. You got a statutory violation and a death. So we prefer not to use draconian tactics to get the hospitals on board with this. And the hospitals are beginning to see that they're concerned with the number of mentally ill people appearing in their emergency departments. And then I point out, well, this is self-inflicted. If you handle these matters properly, they won't be coming back to see you all the time.
Can I follow on with a question about that? Does insurance somewhat tie the hospital's administration's hands from releasing people too early?
I think insurance is a problem, but insurance does not obviate your statutory duty to provide 5 days notice of discharge to the CMH. So it's a requirement in the statute. And I know that Judge Burton has sent correspondence out to all the presidents of all the hospitals that serve Wayne County, which is the Tri-County area, advising of their statutory obligations and that the court is prepared to enforce those obligations using the contempt powers of the court if it has to. We prefer not to, but we're prepared.
Thank you for that answer. Melissa Kavlich has a question about, does AOT include persons with TBIs, traumatic brain injuries?
It's a good question. I don't really know the answer to that question, but I'd have to take a look at that one.
She would like a copy of the slide presentation. Do you mind if I send that out in a post follow-up email to the attendees?
Oh, no.
Send out your slides.
Everyone's welcome to have it and do what they will with it.
We'll send those out then. Thank you. She also said, Melissa said, our governor for California is creating care court for persons with SMI. Have you read anything about it? And if so, does it sound familiar or similar to AOT with courts in your state?
I have read about it. I prefer our system. We have our system is less complicated and it's required across the state. Anyone can file a petition for AOT only without having medical testimony first, or without getting a certificate. So I think it's more flexible, but I think California, they had a long way to go, and this is a major improvement. But as I understand it, it's not quite applying across the board yet. It was interesting to me that in Michigan, our disability rights community supported the amendments in the law because they recognize that incarceration is not better than AOT. And I know that's been a bigger challenge in California to get that point across.
Also, another question that kind of tags along with Kathy Bullock's question. They're saying AOTs in your state only linked to county services, or can they use a private AOT that will willingly comply with MOU? Is it state by state, or county by county versus state, or can there be any state level laws implemented?
Well, it is county by county. It's actually kind of region by region. It's community mental health system. Like, for example, Wayne, Oakland, and Macomb counties, the big three, Kent County, they each have a CMH that covers their county. But in northern Michigan, you might have several counties that are part of a CMH. So it's currently CMH based. But we are seeing the development of Michigan's a pilot project for the community, the CCBHC program, which has the advantage of being able to treat people regardless of income. What that means is if you have insurance, they'll still treat you. If you have an income, they'll still treat you. But that's part of our problem with the CMH system. We don't have general fund money to support persons who are not general fund eligible. So we've actually asked the legislature to provide funding to support AOT for persons who are not Medicaid eligible. Why should we wait for someone to become disabled before we start helping them?
Good. And is a CMH, can you define that? Is that the same thing as a CCBHC?
No. The CMH is the Community Mental Health Organization, which is basically funded through the state. And for example, in Wayne County, is Detroit Wayne Integrated Health Network. They have about 80 providers across the county that provide services funded by the state. On the other hand, a CCBHC, it can be a CMH, but it can also be a private provider, private not-for-profit. And we have several of those, and we have 3 or 4 in Wayne County right now that are private not-for-profit mental health agencies that can now accept patients as a CCBHC. So I think the CCBHC has the potential to be the outpatient model promised in 1963.
Great, thank you for that. And Eric Diaz asks, has AOT in Michigan led to less guardianships being ordered?
I would say not yet. That's going to take some time we're trying to get, for example, Wayne County has about 700 people on AOT. Genesee County has a few 400, and they're the 2 largest ones. So, and frankly, what we're doing now is we're still trying to get things moving more broadly. It took a while to get to where we are. But I think as we see more and more of AOT-only petitions being filed, that with those kinds of petitions, we should see a reduction in guardianships. That's our hope. It's our objective, but it's going to be a few years to see whether that works. And we also have to wait a few years to see how well AOT works over the long haul. We know, for example, the problem-solving courts, the recidivism rate for a problem-solving court is the same for graduates and non-graduates at different time cycles. So after 2 years, the recidivism rate for graduates is pretty good. But after 4 years, it's about the same as it was for about 2 years behind. So we're deferring recidivism and problem-solving courts. They're still helpful. But then for the AOTs, are we providing longer-term relief or not? And I guess how the long haul is, how long can we prevent hospitalization as well as incarceration? So we know that in Wayne County, we're seeing some early reductions in hospitalization costs, but we're not yet sure we can tie that to the new program. It just remains to be seen. We're still early we're still early on implementation.
Do you know, Kathy Manders asks, do you know if the state of Florida has a similar system to Michigan with the AOT program? And has their success with AOT been presented to our lawmakers in DC? If not, it needs to be. She says, thank you for all you're doing, Judge Mack.
Well, Florida is not. So they don't have a system like Michigan. And if they did, it'd be a good idea.
How would families, those of us with loved ones, maybe start impacting forming a mental health diversion council? Well,
that's formed by the governor.
Oh, okay.
So
how do we influence that?
Well, that's NAMI has influence these days. They're growing in influence. Finding a champion, finding a legislator who's a champion. Now, I was fortunate because the lieutenant governor at the time was very supportive. I had actually become kind of frustrated, and the local TV station asked me if they could film a mental health case. And early in my career, I probably would have said no, but I decided, you know what, the public should see this. So they filmed it. They ran it on the news. And then next thing I knew, they wanted to do a 5-part series, which they did, titled Waiting for Disaster. And that triggered a phone call from the Lieutenant Governor. How do we fix this? So that was fortuitous. But anyway, I had a Lieutenant Governor who was rock solid on board to help push this. And he pushed it with the Speaker, who was supportive. So you need a champion, basically, in the legislature who will push this.
Wow. Thank you for that information. That's really great insights for us there's some here that are, haven't gotten their toes dipped in the water of legislative activities yet or are wondering about that. So thank you for that.
It's not easy. I was on the Mental Health Commission in 2004, and most of the things I suggested then didn't happen until 2018. In fact, in 2004, I suggested mediation of mental health proceedings, and I didn't get that done until 2020. I don't attribute that to my own incompetence or inability to get things done, but I attribute it to it's not easy.
It takes time.
It takes time, but the advantage those of you who have not gotten there yet do have now is that other people have gotten there. They paved the way, so it makes it easier for people who are coming afterwards. But you can point to success.
Showing us for your state's success and being so instrumental in that. We are going to close the Q&A at this time. If you had a question that was not answered or you'd like to submit one later on, please contact the coordinator email at coordinator@National Shattering Silence Coalition.org. I think Ann Corcoran will put that in the chat so that you guys can see the email that we use, the common email. We will forward those on to Judge Mack for him to return those answers to us to get to you. And thank you, Judge Mack, for your graciously delivering this knowledge to us tonight. We are happy to have had you kick things off for our Pro and Peer Talks. We appreciate your dedication to those suffering with serious mental illness and helping us in other states to model after Michigan and to reach the progress you guys have made, and hope and wish the best for you guys in Michigan to continue on that road. So we want to thank you again for being here tonight.
Thank you. It's my pleasure. Appreciate it.